Okay, thank you, and also good morning from my part to all of you. The title of my presentation today is quite wide, validity of jurisdiction clauses in bills of lading. There have been entire books written and numerous articles about this subject, so I'm clearly not going to give you a complete overview of all possible aspects having to do with validity of jurisdiction clauses. I'm going to focus on the EU law in this regard, and then primarily even within that limited subject, focus on a recent case, a recent decision of the European Court of Justice in Maersk Alliance. Now, by way of introduction, why do we need to talk about the validity of jurisdiction? Why is that an issue at all? Probably all of you know that in practice, all bills of lading contain a jurisdiction clause. I mean, if you ever find find a bill of lading without a jurisdiction clause, then you absolutely have to frame it and hang it above your bed, because that's absolutely unique. So in practice, every bill of lading has a jurisdiction. And in general, of course, and it's also well known, there's nothing remarkable, there's nothing really problematic about jurisdiction clauses. They are absolutely well known. They are used very often in all sorts of contracts. And in principle, jurisdiction clauses are perfectly valid and fine. That are not already referred to charter parties, you find them there, you find them in shipbuilding contracts. I'm not aware of any case where a charterer signed a charter party or ship owner signed a shipbuilding contract and then afterwards said, oh, I did sign the contract, but I'm not bound by the jurisdiction. That simply doesn't happen. Bills of lading and also always have jurisdiction clauses. Their jurisdiction clauses are indeed an issue. Are very often were already contested when I started in practice in 1993. They had been contested since as far as I could look back in case law, and they are still contested. Why is that? Well, the reason is quite simple. The reason is because the bill of lading is a negotiable document. It is meant to be negotiated. It is meant to pass beyond the initial parties, to be negotiated, to transferred to third parties, to be used by third parties. And that is why jurisdiction clauses in bills of lading are an issue. Because of that question, to what extent is a third party holder of a bill of lading? Party that was not the shipper, was not an initial party to the contract of carriage. To what extent is such a third party bound? Move this little black box out of the way, if I can put that too far. Yeah. Then we'll have to just leave it. As I said, I'm going to focus on EU law, and most people within the EU thought that this question was quite settled by two cases, very well-known cases, the Tillerud decision of 1994 and the Maritime decision of 2000. Those two main cases, there are quite a lot of other cases also, but those are the two main cases. And the Court of Justice, the European Court of Justice said, well, the question that has to be decided, the main decision line is you have to look at whether a third party holder of a bill of lading steps into the shoes, as it's sometimes said, meaning is that third party holder succeeding to all rights and obligations of the ship? Succeeding to, subrogated to, the terminology is a bit vague and changes from one decision to another. That is the main question. What is the position of a third party holder? Does he step into the shoes? does he succeed to all rights and obligations of the shipper or not? If the answer is yes, your third party holder does indeed step into the shoes, does indeed succeed to all rights and obligations of the shipper, well, then he is automatically bound by the jurisdiction. Provided, of course, that that clause had been initially validly agreed between the shipper and the carrier, but in a lot of cases, that is indeed. No further questions, no further requirements. That is also very logical. If you say that a third party holder actually succeeds to all rights and obligations, steps into the shoes of the shipper, well, then obviously he is also bound by a jurisdiction clause that has been agreed by between the shipper and the carrier. If the answer to that fundamental question is no, that's basically the correct maritime scenario, then a third party holder is only bound by the jurisdiction clause if the third party holder himself has actually agreed, as the court in correct maritime has actually agreed to that jurisdiction clause in his own relationship, the third party holder against the carrier. Question then, of course, is, well, when is a third party holder succeeding to all rights and obligations? You won't find the answer to that question in any of the carriage contracts. Hague-Visby rules, Hamburg, even Rotterdam, they don't give you a specific answer to that specific question. So obviously, since the conventions don't say anything about that, this is a matter for what the court called in the relevant, later the applicable national law. This is something for the national law to decide whether or not a third party holder steps into the shoes, succeeds to all rights and obligations. And then, and this is something that the European Court already decided in Tillerus in the 1980s. Question, of course, then was, well, what is that applicable national law? How do we determine this applicable national law, which has to give you the answer to the question, is a third party holder stepping into the shoes? In correct maritime, the Dutch Supreme Court explicitly asked this question from the European Court of Justice. The European Court of Justice said that question is inadmissible. This is not a matter of interpretation of the Brussels I regulation, and thus it's not for the European Court of Justice to decide. This is for the court seized to decide based on its own rules of private international. Enter this case of this decision of last year, April, in three joint cases coming out of Spain, Maersk against Alliance. Before this case, based on Tillerus, based on correct maritime, I would say that most European maritime lawyers thought, well, we now know what the situation is, we know how to deal with these issues. ECG in Maersk has brought some clarifications, welcome clarification, but has also created some new doubts. What is in a nutshell the decision in Maersk? Well, it deals with the Spanish Navigation Act, Ley de Navegación Marítima. Articles, there are two, Article 251 and Article 468, I think, from the top of my head. That Spanish Act requires explicitly, but also explicitly without prejudice to EU law, requires jurisdiction clauses to be individually and separately negotiated. And there the Court of Justice has said that is such a provision, these provisions of Spanish law are a violation of EU law, and thus they cannot be applied because Spain is obviously a member state and must comply with EU. What are the clarifications? Well, there is a first clarification where the older cases like Tillerus, Castelletti, Correct Maritime, they talked about the third party holder succeeding to the rights and obligations. Now, in Mars, the European Court explicitly talks about succeeding to all rights and obligations. There might signify a real difference. I personally don't think that that is a real difference, and that is purely a matter of terminology. If you read back the original Tilly-Russ case, the Tilly-Russ decision, even there, the European Court already used, although they also talked about succeeding to the rights and obligations, they also explicitly referred to the holder becoming vested with all rights and becoming subject to all obligations. So that all wording is already in the Tilly-Russ decision. There are references to assignment, to the holder becoming an assignee. Assignment explicitly means that you take over all the rights and obligations. And I think even the most important argument is that if you were to say that in the older cases where the court talked about succeeding to the rights and obligations, if you were to say that the rights and obligations is not all rights and obligations, well, then you're saying that the court was talking about a third party holder succeeding to some rights and obligations. As Rian said, you cannot qualify all is all. If you are going to say that the rights and obligations basically mean some rights and obligations, well, then you put yourself into an unsolvable chaos, because there is no indication, no hint whatsoever in the Tilly-Russ decision as to where you would have to draw the line. Which rights and obligations would a third party holder have to succeed to, which could be neglected. So I think, and now in Mars, of course, the court is explicitly using the term all rights and obligations. I think that has always been the case, actually. The second clarification that the court brings, and again, a welcome clarification, we know already that the applicable national law has to be determined by the court seized. But there was an argument in Mars cases that the court seized, in the Mars case that was a Spanish court, that the court seized should apply the law of the chosen. In the Mars case, that was the English High Court, the London High Court. So the argument was, in determining whether a third party holder succeeds to all rights and obligations, the Spanish court should apply English law, should ask itself, well, what does English law say about the position of a third party? That is not a completely strange argument, because Article 25, paragraph 1 of the Brussels I regulation, when it applies, when it concerns the substantive validity of a jurisdiction clause, does indeed explicitly refer to the law of the chosen. If you have a jurisdiction clause in favor of the London High Court, and there's a question about substantive validity, the court must indeed, by the express words of the regulation, must apply English. European Court of Justice says yes, but that is a rule that only applies to substantive validity. We cannot extend that rule. We cannot apply that rule by analogy. So the court seized, Spanish court in this case, has to apply its own rules of private international law to determine which law is the applicable national law, which law is the relevant national law, and then use that applicable national law to answer the question, does a third party holder succeed to all rights or obligations? And of course, the rules of private international law, the court sees, may very well lead to the conclusion that it's that court's own law that governs, that applies to this. Not familiar with the Spanish private international law, but it would be perfectly possible that the Spanish court says, well, applying our rules, we come to the conclusion that for example, because it was a carriage to a Spanish port, a carriage from a Spanish port, it's Spanish law that applies, and we thus need to answer the question with regard to the position of the third party holder on the basis of Spanish. The two clarifications: all rights and obligations, and it's the seized port that has to decide. Where does the doubt come from? Well, the doubt comes from the fact that the European Court of Justice has said, well, our earlier decisions in Tilly Russ and Court Maritime, they are the correct interpretation of what is now Article 25, paragraph 1, and all of its predecessors. And the court says, well, EU law takes priority in EU member states. National law cannot add requirements that do not exist in European law. All of those three first points are, of course, obvious and correct. And then the court comes to the conclusion that the Spanish Navigation Act actually violates the interpretation of the court in Tilly Russ and Court Maritime, because it does indeed add extra requirements, as at least in the opinion of the European Court of Justice. What is the problem there? Well, the problem is that the European Court itself in Tilly Russ and Court Maritime has said, well, there is a difference. There are two different situations, scenarios, how you want to call it. In Russ, the third party holder steps into the shoes is automatically bound. Court Maritime, third party holder does not step into the shoes, has to accept jurisdiction clause himself. This is a decision that is not told up by academics or something. This is the difference, the distinction that the European Court itself created. And then in Mars, they completely disregard that difference. There's not a single word about the difference between these two scenarios. What is clear from the decision is that the European Court implicitly, but very clearly, thinks that they are dealing with a Tilly Russ scenario, where the third party holder does indeed step into the shoes, does indeed succeed to all rights and obligations. There's wording that is repeating that concept of the holder succeeding to all rights and obligations. And the Spanish Act is actually criticized for the fact that it is, according to the court, granting more rights to the holder than to the shipper. And that is something that the court in Tilly Russ already said, that is impossible if the holder steps into the shoes of the shipper, because then he simply takes over the exact same position of the shipper. If the shipper did not have the possibility to contest the jurisdiction clause, then you cannot give a third party holder the possibility to do exactly. So if this was indeed a Tilly Russ scenario, the holder stepping into the shoes of the shipper, and the decision of the court is right, then indeed an EU member state cannot, in its national law, add further requirements on top of the European law. The main problem is with this entire decision is that this wasn't a Tilly Russ scenario, or at the very least, the court, the European Court, did not have the information to decide that it was a Tilly Russ scenario. Article 251 of the Spanish Navigation Act says that the holder acquires all of the transferor's rights and actions over the goods, with the exception of jurisdiction and arbitration rules. If you say that he acquires all rights except, no, that's the same as saying that he does not acquire all rights. Again, Riddian's point, all is all, you cannot qualify that, it's either all or it's not. Furthermore, and maybe even more importantly, Article 251 doesn't say anything about the obligations of the ship. And you can only have a till rust scenario if the third party holder succeeds to all rights and obligations of the ship. And almost to add insult to injury, the Spanish referring court itself had, in the questions that it put to the European Court, had explicitly stated that, they call it the subrogation of the holder, that the subrogation of the holder under Spanish law is only partial. If it's partial, then you're not in a till rust scenario, then you're in a correct maritime scenario. Again, the court in its decision doesn't even mention the correct maritime scenario, doesn't even mention that possibility. They're just blindly focused on till rust. But ask yourself then, of course, well, why? How come? Why is the European Court of Justice so focused on this till rust scenario? And why are they completely disregarding the correct maritime scenario? Again, it's the court itself that has created this. Part of the, or an indication of the answer may be found, I think, in two non-maritime cases, Refcom AXA of 2013, and a later case, Profit Investment, 3 years later, where they basically repeated what they had already said in Refcom. In these two cases, and again, those were non-maritime cases, first the Attorney General, and then the court itself said that under most legal systems which agree on this issue, a purchaser of goods becomes the bearer of credit and the holder of all rights and obligations of the ship. Where they got that from, no clue. There's no justification of that. There's no single source for that cited. That's just the Attorney General in the Refcom saying, under most legal systems, the holder does succeed, the holder of a bill of lading does become the holder of all rights and obligations. And then the court simply, literally, verbatim, took that over from the Attorney General. Now, that is, of course, inherently contradictory. On the one hand, the European Court is saying, well, we have this difference, this distinction between the till rust scenario and the maritime scenario. And it's for the court seized to determine, based on their on the applicable national law, because the Brussels I regulation doesn't say anything about this. It's for the court seized, based on national law, to determine whether or not a third party holder succeeds to all rights and obligations of the shipper. And then in Refcom and Profit Investment, that same court is saying, almost as a sort of statement of principle, oh, well, the bearer of a bill of lading becomes the holder of all rights and obligations of the ship. That is a clear contradiction between those different decisions. And not only that, it's wrong. I mean, there's no other way of putting it. That is simply wrong. There are, in my own country, Belgium, there are several decisions of the Belgian Supreme Court where the Belgian Supreme Court has explicitly and in so many words said a third party holder does not step into the shoes of the ship. That is, by the way, case law that is unanimously followed by the lower courts. In the Netherlands, a third party holder is considered to be a third party beneficiary. So he does get some rights, he does in some cases also get some obligations, but he's not seen as stepping into the shoes of the shipper. He doesn't take over all rights and obligations of the ship. Same in France, there also the position is that a third party holder does not step into the shoes of the ship. And I would say that even in the UK, the prime defender of jurisdiction clauses if there are London ports, of course, the prime defender of jurisdiction clause, even there, a third party holder does not really step into the shoes, does not really succeed to all rights and obligations of the ship. If that was the case, then Coxside could have simply stated the third party holder, upon acquiring the bill of lading, succeeds to all rights and obligations. Then you would not need the very elaborate regime that we now have in sections 2 and 3, where they're splitting up the rights under bill of lading on the one hand, liabilities under the bill of lading on. So, my opinion, even under English law, a third party holder is not stepping into the shoes, is not succeeding to all rights and liabilities. I obviously don't know all of the European laws, so I would be very interested afterwards to hear from you what in your country the position is, whether you consider, for example, here in Croatia, whether you consider a third party holder to be succeeding to all rights and obligations of. So that leads me to the conclusion that apparently the European Court of Justice is working from the assumption that the Tilly-Ross scenario is the rule and that the correct maritime scenario is the exception. Whereas in reality, it's exactly the opposite. It's the correct maritime scenario that is the rule. The third party holder is not succeeding to all rights and obligations. And the Tilly-Ross scenario is the exception, maybe even the rare exception. I currently don't know any maritime law where a third party holder actually really takes over all of the rights and obligations of the ship. Now, what is the consequence if indeed the court would have said, as it should have, that this is actually a correct maritime scenario? That means that, again, the decisions of the European Court itself, that means that the third party holder does not step into the shoes of the shipper, that he only becomes bound by the jurisdiction clause in the bill of lading if he himself, if the third party holder himself has actually accepted that clause in his own relation with the carrier. Why is that so? And again, this is the European Court's decision itself, but I completely agree with that. That is because there is a fundamental requirement for jurisdiction clause, and that has been repeated by the European courts in at least, I think by now, more than 10 different decisions. A jurisdiction clause is possible, is valid, on condition that there is a real consensus between the parties. And even more so, that real consensus can only be proven in one of 3 different ways, as stated in Article 25. Don't forget, the parties we're talking about here are the third party holder and the carrier. We're talking about a correct maritime scenario where the third party holder does not step into the shoes of the shipper. So the parties between which you need a real consensus are the holder and the carrier. How do you prove that required consensus? You won't find the answer in the Brussels I regulation. The Brussels I regulation, as the European Court itself has confirmed, doesn't say anything, doesn't govern the effect of jurisdiction clause on third parties. This question, how you can prove the consensus, the agreement between a third party holder and carrier, that clearly is a matter of national law. And for example, in the Belgian shipping code, which was promulgated quite recently in 2019, we have a sort of a negative rule of proof. In the numbering of the articles has become very complicated. Article 26224. the agreement of it, this article says that the agreement of a third party holder with a jurisdiction, an arbitration, or is not proven by the mere fact that the holder has accepted the bill of lading, or by the mere fact that the holder has requested and also obtained delivery of the goods. That is what a holder always does. That's the reason why you want to get a bill of lading. So the simple fact that the holder has indeed presented the bill of lading, has gotten the goods in exchange, that in itself does not prove that the holder has accepted the jurisdiction. Well, our Spanish Navigation Act, which the European Court of Justice said is a violation of European law. That act, in a correct maritime scenario, of course, can also be read as a rule of proof. It says, remember, that jurisdiction clauses are only valid if they are individually and separately negotiated between the third party holder and the carrier. Again, we're in a correct maritime scenario. That can perfectly be understood as a rule of the applicable national law that is meant to ensure that there is indeed an actual agreement, a real consensus between the third party holder and the carrier. Thank you.